I think it's time. First of all, the Supreme Court has found in the Constitution an individual right to bear arms. And I don't find that in the Constitution. Constitutional scholars don't find that in the Constitution. It was a either a 5-4 or a 6-3 decision. And I think it's wrong, and I think it's time to revisit it. And Article 3, Section 2 of the Constitution gives to Congress the right not only to regulate the Supreme Court, but to determine what the Supreme Court can and cannot rule on. The Supreme Court has taken far more power than it was given in the Constitution, and I refer you back to the Federalist Papers, the 80s, the early 80s, 80, 81, 82, 83, 84, by Alexander Hamilton, in which he said the Supreme Court will be the least offensive among the three branches of government because they have neither the power of the purse nor the power of the sword. Right? Congress controls the money, the executive branch has the army. So they can't make law, was the idea. But they have been doing that, and they've been doing it aggressively largely since the 1970s, since Lewis Powell was put on the court. Although Phyllis Schlafly would argue that they've been doing it since, in a big way, since 1954 with Brown versus Board. The right-wingers, that's their bugbear. I think that the first case where the Supreme Court struck down a law was 1803 Marbury versus Madison. The next one where they actually made law was 1856, Dred Scott. That led right to the Civil War. That worked out really well. And then there are a couple in the mid-19th century that are not of great consequence, but the big one was in 1898. It was Plessy versus Ferguson, and it created separate but equal. And that got, of course, overturned in 1954 in Brown versus Board. But the fact is that the Article 3, Section 2 of the Constitution says, the Supreme Court shall have appellate jurisdiction both as to law and fact, with such exceptions and under such regulations as the Congress shall make. So Congress could literally pass a law saying, we're going to regulate guns in this country. You have to demonstrate that you are a sports shooter or that you are a hunter or that you have a need to carry a gun in self-defense or something. I mean, I'm not even sure I want to go that far, although that's, I mean, you know, pretty much every other developed country in the world has gone way beyond that. But I would say, and again, Congress could pass this law and simply build into the law a rider that says the Supreme Court can't overrule us. And this has been done, by the way, in the past. We've had Phyllis Schlafly on this program in the past. She wrote a book about this called The Supremacist. She's all upset because Tom Daschle did it. You know, she hates it when Democrats do this, but it has been done. It was some kind of farm bill or something that involved South Dakota, North Dakota. And, I mean, back in the day, right? But I think that the way to deal with guns is threefold. These young women who were shot and murdered, and I realize the first three killings were knifings, you know, his roommates. But that said, then he went on a gun rampage and he had hundreds of rounds of ammo in his car. These young women are going to get nothing. Had he run them over with his car, as he did a few other people, his insurance company could be paying out millions. So why don't we regulate guns the way we regulate cars? Really, really simple. It has to be registered from the time it's manufactured until the time it's destroyed. Every year you renew the registration with the state, or every couple of years. You know, you get a new license plate. Basically, that's renewing your registration. Number one, it has to be registered. The gun, its serial number has to be registered. Number two, as a user, you have to demonstrate proficiency, the equivalent of a driver's license. Right? Show that you know how to shoot. Now, I say this as a sports shooter myself. I am not an opponent of guns. My brother, one of my three brothers, is an enthusiastic sports shooter. He has a gun range in his backyard. And Louise and I go back to Michigan. There's a picture floating around the internet of Louise firing either it was a 25 target pistol or Steve's 40 caliber Glock. I'm not sure which it was, but if it was the Glock, the picture does not capture the kick. But in any case, you know, I go home for family reunions and holidays and things, and a couple of my brothers and a few of my nephews and nieces and I will go to the gun range in Mason, Michigan, or we'll go, if we're up at Steve's house, we'll go in his backyard, we'll do competitive shooting. I have no problem with that. But register the gun, license the user with regard to proficiency and competence, not insane. And number 3, and most important, insure. Just liability insurance. Liability insurance is cheap. We're talking about what would probably be $30, $40, $50 a year policies. But you must have a liability insurance policy if you own a gun. I mean, here you had the Newtown shooter killed, 30 kids, 28, 36 kids, 26 kids? The numbers blur into my mind because there have been so many of these massacres. Not a single one of them got a penny. If he had hit them with a car, Geico would be paying out. So why don't we just regulate guns like we regulate cars? I mean, nobody finds that objectionable. Well, I know there are libertarians who think we shouldn't do that. Anyhow, back to the slave patrol. I wrote a piece called "The Second Amendment was ratified to preserve slavery" back in January of 2013, and you can find it easily on the internet. It was published both on Alternet and on truthout.org. And this was Patrick Henry in 1788. Virginia was deciding whether or not to ratify the Constitution. And he said, let me call your attention to that part. He was talking about Article 1, Section 8 of the Constitution, the part that gives Congress the right to raise an army, which gives the Congress power to provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States. By this, sir, you see that their control over our last and best defense is unlimited. In other words, because he was worried about slavery. He was the largest slaveholder in Virginia, Patrick Henry. If they neglect or refuse to discipline or arm our militia, they will be useless. The states can do neither. This power is exclusively given to Congress. The power of appointing officers over men not disciplined or armed is ridiculous, so that this pretended little remains of power to the states may, at the pleasure of Congress, be rendered nugatory. In other words, eliminated. And, Patrick Henry goes on to talk about the number of slaves in the state. And he said, did we not see this in the last war? He said, in this state, there are 236,000 blacks, and there are many in several other states. But there are few or none in the northern states. And yet, if the northern states should be of the opinion that our slaves are numberless, may they not call forth every national resource? May Congress not say that every black man must fight? Did we not see a little of this in the last war? And that's what the British were doing. They were saying, freed slaves, we'll give you your freedom.
You're listening to the Thom Hartmann Program. Call 866-987-THOM.
So Patrick Henry and George Mason and Melancon Smith were demanding the Second Amendment to protect the slave patrol.